So today's webinar is about liquidation. As you've seen, liquidation is a wonderful tool to use in these difficult times of ours for clients. You and I work with clients who are in trouble and we've got to help them. Today I'm going to tell you how it works, when do you liquidate, will you lose everything, do you keep your assets, do you keep on trading? And today the whole world will decide that I am getting emails. So we're going to look at all that briefly, and I'm going to talk fast because we've got all to get on with our day. If you stay until the end, we'll send you a free liquidation handbook that I've written that you can give to your clients or for your own use if you want that as well. And I've already introduced myself. I just want to add that I specialize in insolvencies for the last 10 years. In 2008, when the last crash came, I switched to insolvencies because I've just got a passion helping people. I can't bear it if they go through pain and drama and there's solutions out there. So I'm going out of my way to help people and educate them. And people don't know that they can get rid of SARS. Everybody's scared of SARS, but you can get rid of SARS debt through a liquidation. And being an entrepreneur myself, I know and understand the pain and fear that business owners go through when they have a problem. So what is liquidation? Liquidation is not just getting rid of a company that has debt. Liquidation is one of the tools that we use in the restructuring of a business. It's like cutting the arm off I'm sorry, of a tree, and the tree can live. So you get rid of the debt, but you can continue to trade at the same time. And forgive me, our clients all, the minute I've spoken to them, they go from this stress, I can see how relaxed they are because they understand that this is not the end of the road, but actually just a way to deal with your debt. How does liquidation work? We all learn it when we study. You learned it, everybody's aware of liquidation, but in practice it works quite different from what we learn, in the sense that practically liquidation is not as stern and as heavy as the Act is. They don't really enforce everything that's in the Insolvency Act, because if they were, nearly everybody would be in jail, because you get threatened with criminal charges if you do this and that. It's not true. They don't enforce it. If they will, if they have to, but they don't really. Liquidation is prescribed by the Companies Act. I'll talk about that later. And the process is prescribed by the Insolvency Act. The interesting thing about liquidation is that all the creditors come together. You don't have the case where one creditor takes legal action, takes all the assets, and that's the end of the business. In fact, it's called a concursus creditorum, where they all come together in one pool, and then they must share in the proceeds of the business, if there are any, in a certain order. So it's a much more structured process, which is actually a very necessary process if you want to protect your client as well as creditors. This is the way to go, because instead of the director getting the opportunity to get rid of assets and money and creditors taking everything and there's nothing left for everybody else, this is the way to go, because then the client can't get rid of assets. The assets are sold to the benefit of all creditors, and they are managed so that they don't go rogue and wild and drive your client crazy and sometimes absolutely to suicide. So when do you liquidate? As soon as possible. The moment a company cannot pay its debt, there's a duty prescribed by the Companies Act that the director must liquidate. The Section 22 says that you're not allowed to trade under insolvent service circumstances or reckless. You must liquidate immediately. So that takes the emotion out of the decision. You've got to liquidate, otherwise there's penalties to be paid. So trading recklessly is also a term that everybody talks about but nobody really understands. You trade recklessly when you are reckless in the management affairs of the company. Very technically, if you do not liquidate the moment that company cannot pay its debt, SARS included, you should liquidate. But things don't work that way. People try to trade out of it. They trade longer. They're hoping they can fix the problem. But in actual fact, if you look very sternly at Section 22 and clinically, then you should liquidate the moment you can't pay your debt. And at the same time, we're working with money, so the sooner you liquidate, the sooner you can recover. I see so many people who tell me I'm going to trade out, or my accountant said I must trade out, or my lawyer said I must trade out. And that's not always the best advice, because if you work with money, it snowballs, as we all know. Look at my little snowball. It's going to get bigger very soon, because if you start having trouble, you've got to earn triple what you earn, because you've got to pay them debt backwards, you've got to break even, and you've got to make a profit. And 99% of businesses that I have to talk to or that I deal with, they're not in that position, especially under the current circumstances. People won't easily recover now. So trading out is not the solution. It's really not when it comes to money. People who trade too long and have all these problems with finances, and they've got to manage their affairs, and they plug a hole here and they plug a hole there, is to me like a person on a lilo. They're so busy plugging the holes that they don't look at the solutions. They don't get off and they swim to shore. And liquidation is the shore where you can swim to solve the problem. And the lilo can do its thing in the middle of the dam. And money, as I said, is working backwards. Nobody knows that better than you do. You more focused on money and money affairs than I am. And if money just goes into a bottomless pit if you spend it backwards. And that's the reality that one has, that I usually bring to the fore for my clients on their minds, because they don't think about money that way. So liquidation is immediate. You get rid of the debt of the company immediately. The moment you decide to liquidate, you stop paying all debt. I'll help you to the client to restructure so that he can continue, but that is a dead duck and it's gone, and we bury it as fast as possible. I always tell my clients what liquidation can do for them. When they have sleepless nights and they don't eat and they worry and they're busy managing this and they're busy managing that, they're paralyzed and they get stuck. They get stuck because they don't know the solutions. They don't know what to do. When you've decided to liquidate and you understand the process the way I do it, because not everybody does it the way I do it, but the way I do it is to help the client to focus on the solution and not on the problem, because there are solutions. It's not the end of the world. It's just a restructuring process. And the minute they can understand that, then all those things happen. Creditors stop chasing you. You can start over fresh with a better plan, better structure, better everything. So once the client has made the decision, and that's the hardest part, I will send them forms and then we're going to liquidate the business. Also, we can then liquidate the business either in the High Court or in the company's offices. I don't go to the High Court anymore with liquidations if I can help it. I only go to the High Court with liquidations if there's a deadlock between members, if there's something difficult or untoward or worrying, then I go to the High Court. And the reason for that is that the High Court is full. Court rolls are full. And if your client is in a hurry, sometimes SARS is chasing them, you want to get rid of the company as soon as possible, High Court is not the road to go. So if there's no deadlock and there's no other problems, we go to the company's offices. So by far, at the moment, my company office liquidations, I do most of them. I haven't been to the High Court for quite a while. High Court takes about 2 months. An advocate must appear. It costs about 60,000 Rand. And for cash-strapped companies, that's just too much. Company office liquidations, on the other hand, takes about 2 weeks from start to finish, if not less. And it's much, much cheaper. It's about 25,000 Rand. And it's just more affordable. So that's the way we're going. If it's possible, preferably, and that's paper-driven. How does it work? So let's talk, I'm only talking about company office liquidations. I send a form, the client completes it, they send it back, we draft the documentation, they email it back, we lodge the documentation, because the company's offices is very electronic driven and much more organized than SARS, and their systems are working perfectly, and they very seldom have backups, and if they do, they catch up very, very quickly. Very impressed with the company's offices, and I'm sure you all work with them every day, so you know. So once the documentation is lodged, it takes about 3 days, 4 days, max 10 days. I just say 10 days in case they get backed up. But usually it takes about 3 or 4 days. Then the company is liquidated. After liquidation, the clients feel so much better because they feel that the pressure from SARS and all the other creditors are off, because they know they can't contact them anymore and they know they can't take legal action anymore. People's fear mainly are for SARS. I'll talk about SARS a little bit later. So once liquidated, all debt is written off, and that includes SARS. And yes, I know that SARS can, and it's a can this big, in terms of the Tax Regulations Act, collect the debts from the directors and members personally, but you know what, they don't. I've done this since 2008, which is what, 11 years, and I've liquidated people who owe SARS 100 million, 80 million, 60 million, 40 million, and SARS has never once taken legal action against any of those directors in their personal capacity. And even if they do, we can sequestrate the director. So that's not the end of the road either. So you can get rid of SARS. It is very possible. And the thing is, I'll explain to you later, is that SARS don't even bother. The minute there's a liquidation, they close their file. Whether they're going to change their attitude in the future, I don't know, but I don't doubt it. The only thing I'm very worried about in the liquidation is sureties. We've had 100% success with all our liquidations, either in the High Court or in the company's offices, and SARS has never changed any of our clients, and they've all been busy. They've all been able to continue to trade. So what happens once the company is liquidated? A liquidator is appointed. The Master of the High Court must appoint the liquidator. What I started to do is I started to ask the clients to nominate a liquidator. I work with the liquidator because the High Court, the Master of the High Court takes forever. And then this hangs and it's an open case and creditors give you problems. So I'll explain that process to you as well. But the Master appoints the liquidator, and the liquidator's job is to wind up the insolvent estate. So in liquidation is a two-leg process, where the first leg is the liquidation that I do, and the second leg is the winding up that the liquidator does. I am not a liquidator. And if we want our liquidator appointed, we nominate the liquidator, and you nominate a liquidator by signing a requisition form that I draft, and that nominates the liquidator. The liquidator takes those forms to the Master of the High Court, and if they see it fit, they will appoint our liquidator. We get 7, 8 out of 10 appointments where we nominate somebody. The liquidator will hold meetings with creditors, because the fact that you list somebody as a creditor doesn't mean they are a creditor. They must prove that they're a creditor. So there's 2 meetings held by the liquidator for creditors, and they must arrive and prove their claim. If they don't prove their claim, they're not acknowledged as a creditor. If there's proceeds, they will get something. If there's no proceeds, they will get nothing. Nobody will get anything. And that which they don't get, they must write off. And your client can buy back his assets if they want it. They usually want to. It's a structured process. The assets are not removed. If the client indicates upfront that he's going to buy it back, I arrange with the liquidator, whoever is appointed, and we let them know that we want to buy the assets back. They stay where they are. If they need to go in storage, your client must store them. Risky to do that. I don't like if they do it, but sometimes it's necessary, but I'll guide your client through that. But most people are worried about their assets. It's in the middle there. They want to buy it back, or they want to keep on using it, or they're worried that it's going to be taken away from them and they need it for their new business. It doesn't have to happen. Assets that are financed, they will either have to refinance it upfront or settle it upfront and remove it from the company before liquidation, so that can be done. And if it's fully paid, they can buy it back. And you can enter into a payment plan with a liquidator. That's not a problem either. Assets are bought back or sold at second-hand auction values, which are very low. Staff. A lot of people want to continue with trade and they want to keep the staff. If you want to keep the staff, you can just take them over to the new company, you give them a new service agreement, and in the first paragraph, you take them over with their work history so that you don't have to pay retrenchments out of the old company. The old company, that is if you're going to continue trade. The old company is not supposed to favor any one creditor over the other. So if you've got staff, what people usually do is they pay them first. Technically, legally, you're not allowed to do that, but the liquidators usually leave that if the client has done that, because they understand that staff must be paid. But if you want to keep the staff and you take it over to the new company, you don't retrench them in the old company. They just get stopped there. You give them their certificate and you take them over to the new company, and then with their work history. The only problem is that if the new company wants to retrench them, they have to retrench them from the day that they started to work for the old company and not the day that they started to work for the new company. But Usually, if the company can continue, that's not a problem. Any staff you don't want to keep and you don't have the money, you don't pay them because they just become a creditor of the company and they can put in a claim later. If there's money, they're going to get something. If there's nothing, they're not going to get anything. My usual worry about a client who liquidates our rental agreements, if you're in arrears, the landlord would want you out. The risk is that because the landlord has an inherent retention right, he may lock the doors. The landlords take the law in their own hands, and because they think, or they're being advised by somebody, that retention right is automatic and inherent, it's not true. You have to have a court order before you can lock up the premises. If the landlord locks up the premises without an interdict, it will be unlawful. Your client will be able to break down the lock and go in, or go and lay a charge, or take them to court. Landlords do it because they know that usually by the time you're in arrears with rent, you haven't got money to go to court, so they just do it, but it is unlawful. If the client wants to stay in the premises and continue to trade, they have to negotiate with the landlord how they're going to catch up the arrears, if there are arrears, and arrange a new lease in the name of the new company. The problem is that if the landlord locks up the premises and the client needs the assets that are inside, he can't continue to trade, he or she. But that's where the client must talk to me timeously so that I can guide them on how to get the assets out legitimately so that they continue to trade if they're not going to stay in the premises. And then a lot of clients are busy with work that they're doing. If the work is not finished, then and they are trading, and the new company can finish the work. The new company can finish the work for the rest of the 50%. If deposits were paid and the work wasn't done, that can be a problem. The director can be held by personally liable for those deposits, because you're not allowed to use, if I pay you money for reason X, you can't use it for reason Y. So if the work can be finished, I would urge clients to finish it if there were deposit paid by hook or by crook, because it can cause them a lot of problems. And then this is where I need to talk to you, the accountant or the auditor, is that where there's directors' loans. We all know the practice that to avoid tax or to minimize the effect of tax or dividend tax, you put the drawings through as loans. It's fantastic for bookkeeping purposes and it's fantastic for SARS, but it bites you when you liquidate. If there's a debit loan account for the director, the liquidator is most definitely going to call it up. You don't want the director to repay his loan, which isn't really a loan, it was actually his salary. So you must reverse those loans to a salary, and let there be pay as you earn be due, or dividend tax, because that'll be the debt of the company and that will be written off in the liquidation in any case. But don't leave a loan account when your client has to liquidate. You can go back 3 years. If you've already done the books, you can go back 3 years, to my knowledge. You will know better than that. There's lots of accountants and auditors that I work with, and they tell me that they can go back 3 years. If you need to discuss that with me, discuss it with me. You're very, very welcome. SARS, all their SARS except customs and excise taxes are written off. In terms of the Customs and Excise Act, those taxes cling to the manager of the premises and not to the director of the company, and for that reason, the liquidation will not write the debt off. You do not have to bring your financial records up to date, nor do you have to lodge your last returns. And that's where you, as an accountant or an auditor, must be careful, because by the time your client needs to liquidate, you may be out of pocket. So you don't really want to put in more work. If you want to help the client to finish, by all means, do what you're busy with, but don't spend another 100,000 or 80,000 or 3 months to finish up the books. It's not necessary. The liquidators don't ask for that. They're more interested in the bank accounts. Your client is not, the directors are not blacklisted anywhere. They can have 50 companies that are successful and 50 that are liquidated. The only way a liquidation bites a director is by means of a surety. So my first question always to them is, for how much of the debt did you sign personal surety for? Because if the debt of the company is $1 million and he signed surety for $1 million, it's no use that we liquidate the company, because the debt will just shift over. In any case, we'd rather look at his personal sequestration. But any debt you did not sign surety for, and SARS is written off in the debt. Client can continue to trade. We help him to register a new company and continue if he wants to. Personal assets are not affected by a liquidation. I get this question from all the time. What happens to my personal assets? It's not affected by a liquidation at all. The only way it will affect them is that they have sureties and they don't make payment arrangements and they're not going to sequestrate. Nobody's interested in their personal sureties. In any case, protect assets. We can protect the assets. If the client does not want to sequestrate, we can restructure them and we can put their assets in safe places and move it around so that they can be protected. Except for if they've got a house and it's bonded, nobody's interested in the house, they cannot attach it as long as they pay the bond, the house is safe. Any assets that are being paid off under finance agreements are safe. They will not be taken as long as they pay the installments. And in any case, if the director is exposed to such an extent that we can't help him, then we can look at his personal sequestration, and that's a webinar for another day. But the bottom line is that we can help the client to get rid of all the debt in all respects. The problem with liquidation is that it's an emotional decision for most people, but it's wrong to think about that because, first of all, Section 22 makes it a clinical decision. You're obliged to liquidate the company. And then the second thing why it's a clinical decision is that the balance sheet must speak for itself. The company can either pay its debt or it can't. So the sooner the client understands that there's a problem, that he can cut to the chase, that he can, like a surgeon, go in and wipe out the problem, cut it off so that we can start over, the better. It's a great solution. Trading out, hanging on, ignoring the problem is not the solution. And our jobs as professionals are to teach the clients how to do business, because South Africans in general, we didn't go to entrepreneurial school. We all just start our businesses and we run it and we do the best we can, but nobody's got legal knowledge. Nobody's got accounting knowledge. That's why they trust you. That's why they trust me to look out for them. And if it gets to the stage where you see your client cannot pay its debt or that it's going to run into problems, I would like you to consider advising him on the bringing under his attention how liquidation can help them to start over and trade on. That brings us to the end of this lecture webinar on how liquidation works. It's just a broad talk so that you can see what's possible and what's not, and we can go into more details once you've got a client, or if you want to have a one-on-one with me. I would very much like to work with you. The reason why I am presenting this webinar to the accounting profession is that I fully realize that you're the first line of defense. People, you more than anybody else, know when a client is in trouble. Most of the time, you know before your client does. And the more knowledge you have, the better you can serve your client. And as long as you know you've got a lawyer in the back of in your cupboard that you can pull out at any time and ask legal advice, you can ask me on any topic. You are so very welcome to contact me. If you've got clients that are potential liquidations or potential problems or potentially any legal questions, just phone me and ask me. I'm available straight away. So how do we proceed? I would very much like it if you would allow me to contact each of you personally that attended our webinar or that would like me to contact you. I would love to have a Zoom meeting with you so that we can just meet up and see how we can work together. I'll tell you more about that. How can we connect? We can Zoom, we can email me, you can WhatsApp me, you can send me WhatsApp messages, voice notes. I work 24/7. I'm always available. You can contact me anytime. And how do we work together? If you have a client that you think needs liquidation, you can refer the client to me and we can do it one of two ways. I can contact the client direct, or we can have a meeting together. Sometimes that works better because they take your advice and you know in the books what's going on. Sometimes I ask clients, what assets? Oh, no, they don't know, my accountant knows. What's your SARS position? I don't know, my accountant knows. So we can have a Zoom meeting or conference calls or WhatsApp video calls or Messenger video calls. There's so many ways to connect, or we can just email or just phone calls. So that's how we can work together. Why choose me? I can tell you one thing that, first of all, I'm a specialist. I'm not, if you look on the internet, there are loads of people who are advertising that aren't even lawyers. In terms of the Attorneys Act, only attorneys can give legal advice, so that's unlawful. Legal Practice Council is not doing anything about it. I am on a mission to educate business owners about the solutions in these extraordinary times of hours. Most people are under pressure and they fall apart because they don't know that there's this wonderful solution of the liquidation and restructuring of your business. And I need your help because we've got to do this together. I've got a passion for business owners, small business owners, especially because they get thrown in the dark, they get thrown in the shark pool, and nobody's there to help them. And attorneys are expensive. Everybody wants a consultation fee. I don't. I give a free consultation so that the client is informed, so that he can make an informed decision. If he then still does not liquidate and he chooses to trade out, then good luck to him. But at least in the back of his mind, he always knows there's a solution. So I'm not just your normal attorney who's a clock watcher and charges your client for every minute they talk to me. I'm not like that. I'm more of a coach so that I can help them. And I do a lot of counseling because they fall apart by the time they talk to me. So use me, choose me, and work with me, and we can have a great relationship. I've got a lot of accountants that I do work with. And in the back of your mind, you can phone me anytime for any question about anything. If I can answer, I will help it. If I can't, I'll find out. So I'm your lawyer in a pocket. Just phone me. I've got questions for you, though, and I'm going to put on where I can read your questions in a minute. I want to know from you, did the 8 o'clock time suit you? Do you prefer early in the mornings? Would you like more webinars on legal topics? I can also do a webinar on sequestration, part of the insolvency process, which I think I am definitely going to do. Would love to invite you. And then rehabilitation after sequestration. And then also a lot of legal topics that we can talk about with regards to business. I'm a commercial lawyer, so I can talk about a lot of topics, contracts, joint ventures, things to outlook for, rental agreements. There's a lot. And then my question to you is, do you have any legal topics in mind that you would like perhaps me to present as a webinar on, or draft an ebook that you would like to download? You may not want to attend webinars all the time. But those are my questions to you, and I would love it. I really appreciate it if you answer me. And then this is time for your questions. I'm going to look in the chat feed now. I must just find it, where you please type your questions and I will quickly go through them. I don't want to keep longer. And then just again, there's my contact details. My cell phone number, you are always directly on the line to me. I do not have a secretary. I do not believe in secretaries. You talk to me directly. If I'm not available, I'll phone you back when I can, or send me a WhatsApp voice note and I'll answer you back. There's my email address, Nanika@Nanika Law, and there's my website. I'm very happy to share any kind of information with you that you need. I am not a stickler. And then I must also say that this webinar did not happen magically. I've got Jacques Rousseau in the background. I'm told he's called JR. He's an IT tech wunderkind. There's his contact details. There's his cell phone. There's his email. He also has no secretary. He does all his work directly, and he handles all my technical affairs, and he handles all my digital marketing, and he's a great digital marketer. I can absolutely advise him to you if you need digital marketing to be done. There's also a lot of my articles on the Find an Attorney website. If it's findanattorney.co.za, and you can now share screen. I must now stop this so that I can get to your questions. Just give me a moment, please, because as I say, this is new to me. Forgive me for a second. Q&A. There we go. And I see there are some questions. Directors' loans. How do you clear a dividend to remove the debit loan and raise tax, knowing that the company has not met the requirement of assets and liability and ability to pay the debts in a rolling 2 months? That answer I can give you. You will only do that if it's possible. You're not going to do it just because you can. You will only do it that your choice is. You either reverse the loan and turn it into a salary so that there's pay as you earn, or as you earn payable. But if the company did make a profit and you can reverse that loan and it becomes a dividend, then you can pay it out as a dividend. You can't create a profit if there isn't one. So it's just another option of dealing with the option. This person said to me, It's the same person. Business rescue, if liquidation is a better process, then why do we opt for business rescue first? With business rescue, they can reduce the asset and then decide to liquidate. The creditor is in a worse off position. Business rescue is, in my opinion, a terrible idea. You don't have to go under business rescue first. There's no obligation. And as the South African Airways has now proved, business rescue is, in my opinion, a complete waste of money. Your business rescue practitioner is very, very expensive, number one. Number two, by the time you need business rescue, your company is 99.9% already insolvent. So why postpone the inevitable? So you go into business rescue, you pay this person to take over your business. All he does is delay the inevitable. And the only reason I would advise anybody to go under business rescue is if you tell me, I've got a big contract that's coming off in September. I just have temporary cash flow issues and guaranteed my income will be tripled in September. I say rescue, don't go under liquidation because then it defeats the purpose. But the mistake people make in general is that business rescue will not solve the problem. You've got to look at the company, what's going on in the company. If you tell me I've been struggling for the last year and COVID has wiped out all my business, what use is the business rescue going to give you? There's no solution. The purpose of business rescue is to rescue the company out of a period where they can't trade, but it will come right. The purpose of business rescue is not to delay insolvency. So my advice is stay far away from business rescue unless your client has money in the bank that's coming in about 3 months time. That's about the time you need. Otherwise, it's a waste of money, in my personal opinion. Well, as a professional as well. But I'm not saying it never works. I'm saying it doesn't work because people think that business rescue will solve the problem, but it doesn't solve the problem because the problem still exists. Right. If there's any other more questions, let me see. There are no further questions. We can stop the webinar. Thank you. I don't know how to make the screen bigger. Forgive me. We can do another webinar. Please, will you let me know? And also, how do you answer your questions? I'm answering them now, or I can type an answer, Ryan, whichever you prefer. What is your question? I'll hang on a little bit for you. Otherwise, you can email me. My email address is nanika@nanikalaw.co.za, or you can phone me or WhatsApp me or SMS me on 072-855-8106. If you've got any other questions, please ask. If you don't, please let's meet and talk again. I hope you found this valuable, and thank you very much for attending, and I hope to see you at the next webinars. Bye-bye.